Mark, how are you?
Good, how you doing?
Good.
Oh, okay.
Okay, 14. Okay,
You want the workshop?
all right, I will call to order the October 7th, 2025 meeting. This is like that. Please don't close it in one second. I will call to order the October 7th, 2025 meeting of the Alcohol and Tobacco Commission. And I will note that we have a quorum with 3 members present today. Next item on the agenda, disposition of minutes of the September 16th, 2025 meeting.
Madam Chair, members of the committee, we had a meeting of the Alcohol and Tobacco Commission on September 16th, 2025. We've been provided a copy of the minutes. I found those to be appropriate. I move acceptance of the minutes of the Alcohol and Tobacco Commission of September 16th, 2025.
Second. It's been moved and seconded. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next item, prosecutor's recommendations.
Madam Chair, members of the committee, we received a report from the prosecutor on the fines collected for the recent period. There were 93 fines for a total of $55,650. There are 3, interestingly, that are noteworthy. They are all the same regarding tobacco, and they all involve sale of tobacco or vape products to underage individuals. One's from Nirvana of Indianapolis, one from the Food Mart, 2 Food Mart in Scott County, and 1 Evergreen. They involved the sale, as I indicated, of tobacco and or vape products. Interestingly, they are all the 3rd violation, and there has been a consistent agreement between the parties and the prosecutor to a $1,000 civil penalty and 3-day suspension of all of those. I move acceptance of the prosecutor's report.
Second. It's been moved and seconded. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. Hearing judge recommendations. The first recommendation is for TC 170060001, Nancy Forever Incorporated, proposed findings of fact.
Madam Chair, there was a hearing held regarding this matter by Commissioner Mark Jones, who is not here today. This involved the sale of tobacco and vape products within 1,000 feet of an elementary or secondary school. Just for background, in 1996, there was a law passed by the legislature regarding a limit of 200 feet within a school or church property. That was changed to 1,000 feet in 2000, and that they defined in 2024 the school property or building. This involved the sale of a business that did the tobacco and vape products at a particular location within 1,000 feet. As a result of that, the tobacco, since it cannot be transferred, the tobacco permit at that location was surrendered, and a new tobacco license was approved to the permittee Nancy Forever Inc., DBA 4 Cloud 20. They then began business, and there was a complaint filed. A hearing was held before Commissioner Jones. The property is in fact within 1,000 feet of an elementary school. The issue, though, is the sale, and the law applied at the time, while it was admitted even on the application submitted by the proposed permittee that it was within that 1,000 feet. They so did not deny that. It was the tobacco permit was issued. The issue then was, what is the law that applies to at the time? The issue became whether this was a new business or a continuing business. It was technically a new business, but it had been at that location for a number of years. The commissioner found that the legislature has historically protected existing and otherwise law-abiding businesses from new laws and regulations that would have otherwise put them out of business. With that having been said, the commissioner found that there was no violation, that it was an operating business at the time that it was purchased, that he lawfully indicated that it was within 1,000 feet and had the permit issued. And the recommendation was that there be no violation of Title 7.1 and that the permittee Mancy Forever Inc. DBA 4 Cloud 20 can continue to operate. I move acceptance of these recommendations from the commissioner.
Second. It's been moved and seconded. Is there any further discussion?
An interesting legal dispute, but I think the finding is accurate.
I agree, but I also agree with part of the order that there can't be violations of Title 7.1. I think unfortunately we see a lot of sales to minors when locations are placed too close to a school. And so I would say the permittee is on notice that tobacco products can only be sold to persons over 21, and they should strictly comply with that moving forward.
Agreed.
Any further discussion? It's been moved and seconded. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next, hearing judge recommendation is TC 163950001, Avon Tobacco and More LLC. This matter comes on for a proposed order on a show cause hearing.
And Madam Chair, this matter was heard by the Commissioner Jones on August 12th, 2025, and involved two violations of sale of tobacco and products. In this case, the first violation, which was in, sorry, on the page on me, April of 2025, was actually settled and paid. The second violation was shortly thereafter on June 3rd, 2025, on September 25th, 2024. The fact is that this was set for a hearing, and the permittee failed to appear on a number of occasions for the pretrial, for the rule of show cause, and finally for this, there was no appearance. The commissioner heard the testimony and evidence, accepted the exhibits submitted, and is making a recommendation that the tobacco license, both the license TC 1639500 and the location certificate of TC 163950001, both for Avon Tobacco and More LLC, be revoked. I move acceptance of the report recommendation.
Second. Been moved and seconded. Is there any further discussion? Not seeing any. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next, hearing judge recommendation is RC 6189315, Amvets Park County Post Number 61 Incorporated. This matter comes on for proposed findings of fact.
Madam Chair, this also, I heard this on August 14th, 2025. This was a result of an investigation of the Amvets Park County Post 61 in Rockville, Indiana. The facts show that early on, this is a business, a post that has been in operation for almost 25 years. Early in the 2000s, they had significant problems, but those were resolved, and for 16 years, there were no other complaints or violations filed. In 2023, there was a violation for over-serving that was resolved, and the business continued to operate. Then there was another violation for a number of things, including pouring liquor from one bottle to another, failure to have records on site for server permits, no management questionnaire, and unauthorized purchase of liquor. Those matters came before the local board in Park County on the renewal, and having heard that and some other allegations that of events which are occurring at the premises, the Park County Board denied the renewal. That was appealed, and the de novo hearing was held on August 14th of 2025. At that hearing appeared a number of officers and individuals associated with the post who testified that how important the post is to the veterans in Park County and the good service philanthropically that they do. In addition to that, they submitted what I believe is a fairly extensive corrective action plan, which included that between now and February 27th, not of 2026, but of 2027, they will stop serving alcohol at midnight. They will lock the doors at 11:50, ensure that everyone, including employees, are out of the premises at 12:30, and other matters such as a bartender's policy that they will keep track of the number of drinks that are served to every individual, that they will ensure that there is a limited size to the drinks. In other words, they made significant compromises in commitments that I made a part of the recommendation and order. Based upon that and the findings that unfortunately were not presented at the local board, I believe that the local board would have favorably considered the corrective action plan and the demonstration of commitment to preserving the permit and to serving not only the veterans who attend the post, but the community through their philanthropic programs. I move, Madam Chair, based upon this, the recommendation is that the finding of the Park County Local Alcohol Board be reversed, that the renewal be granted for 1 year, subject to the terms and conditions of the corrective action plan, and an absolute commitment to what they also filed as an amended bartender policy on service, keeping track of who is served, and the drinks are imposed. I move acceptance of these recommendations.
Second.
Been moved and seconded. Is there any further discussion? Not seeing any. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next, hearing judge recommendation is RR 0338723 Cultura Entertainment LLC. This matter comes on for proposed order on a show cause hearing.
Madam Chair, this was a matter that was presented on a rule to show cause hearing on August 21st, 2025 by Commissioner Mark Jones. There had been notices sent to the permittee regarding this particular violation, an offer to settlement. There was a failure to appear. There was a failing to appear for the settlement conference. There was a failure to appear for the pre-hearing conference. There was a failure to appear on the rule to show cause hearing. There were a number of violations, I think 11 in total. I won't list them all, but they involve the operation of the bar and other matters regarding food requirements. There were a total of 11 violations. Since there was no appearance, the commissioner heard the testimony and evidence, makes the recommendation that since notice was given and failure to appear, and there appears to be, by preponderance of the evidence, sufficient facts to support this, that he recommends the permit of Cultura Entertainment LLC under permit number RR 0338723 be revoked, and I'm so moved.
Second.
Been moved and seconded. Is there any further discussion? Not seeing any. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next, hearing judge recommendation is RR 2034980 Five Star Dive Bar Incorporated. This matter comes on for an order on a show cause matter.
Madam Chair, there was a hearing held on this matter regarding the violation. The violation had to do with liquor not purchased from a wholesale distributor. And specifically, there were liquor bottles that were actually from another location. And under the scope of the permit, there were other violations filed. This was set for a hearing. There was a show cause hearing and no one appeared. They had previously failed to appear for a settlement hearing. They failed to appear for the hearing in this matter. The testimony and evidence was presented under oath. At that time, having found by preponderance of the evidence the violation to be true, and since no one appeared to represent the permittee, I move that the above permit issued to Five Star Dive Bar Inc. under RR 20-34980 be revoked.
Second.
Been moved and seconded. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. I failed to ask if there was any further discussion.
I have,
All right. Next, hearing judge recommendation is DL 4933441 Central Indiana Package Group LLC. This matter comes on, there was a request by the permittee for reconsideration of the denial to operate during the appeal. I will open that for discussion.
Madam Chair, members of the committee, the Commissioner Mark Jones heard this matter on a request to reconsider the permission to operate during the appeal. He heard some evidence regarding that and made a recommendation that the commission place this on the agenda for October 7th today, and that it reconsider its earlier denial of the permittee's request pending appeal, that the commission grant the request in order that a pre-hearing conference be set on these matters within 45 days. Based upon the recommendation of Mark Jones and following through with his order, I move that we grant the request to reconsider and allow them to continue to operate during appeal.
Second.
Been moved and seconded. Is there further discussion?
I would just note that, I'm gonna vote yes for this, but, I am concerned about it. They did purchase quite a few liquor stores. And when you have that big of a business, you do need to pay attention to all the requirements, laws and regs. And, I don't feel like they were doing that. And we did deny, this permit. It is under appeal. I'm a little mixed on if they should or shouldn't be able to operate during this appeal period, but I'm gonna vote in favor of it for today.
And Madam Chair and Commissioner, while I presented this, I was doing this with the absence of Commissioner Jones. I'm going to vote no on this. There's too much of a history, repeated history of violations, and what I believe is a total lack of commitment regarding the privilege that they have to have a permitted to operate, not just under DL 4933441, but on other matters. And I don't think that this is a privilege. It is not a right. Even the fact that they were granted the petition doesn't give them the right to continue to ignore the rules and regulations of the Alcohol Tobacco Commission, or frankly, the laws of the state of Indiana. I intend to vote no on granting the request to operate during the appeal.
I think I'm torn on this one too, because there were tax issues and then they doubled down on the tax issues by forging a document submitted to the ATC. And while it may not have been the listed owner, I'm not sure how the listed owner was operating a business he was the owner of and not knowing that taxes weren't paid. But they were getting clearances, but taxes weren't going out of the account seemingly. So I think today I'm also gonna be a no. Any further discussion?
No.
And I do agree with Commissioner McGinn that a lot of permits were purchased at auction to create a somewhat large business enterprise in the packaged liquor store market. And it's concerning that responsibility was taken on without seeming to understand or be willing to understand the legal requirements for a business. So for right now, I'm also a no.
Since you've mentioned that, I would interpret with what the things that you mentioned, almost a callous disregard for management, business, and following through with the requirements of the state of Indiana on the sale and distribution of alcohol. It's not just a mistake, it's a callous disregard.
So with that, the motion was for granting an extension to allow operation. So all those in favor indicate by saying aye.
Aye.
Opposed, say no.
No,
No. Motion carries. Next, hearing judge recommendations. These were added and posted on our agenda on the website yesterday, but were not on our original agenda. But notice was sent to the permittee. So can we take it by consent to add TC 148000001 and DL 4132220 Franklin Smoke Time Incorporated to the agenda? This comes on a proposed order to show cause matter.
consent.
Consent.
All right, we will show that added by consent, and I will open that for discussion.
Madam Chair, this was a matter heard again by Commissioner Jones on August 21st, 2025. It involved a case in issues that are presented by violations. There was a failure to appear, again, numerous failures to appear on a virtual settlement on March 10th, on July 31st, on a pre-hearing, and then finally on the hearing that was scheduled for August 21st, 2025. It involved in part the sale of nitrous oxide, which is a violation of IC 35466663, and an issue of public nuisance. Because of the failure to appear, the Commissioner Jones is recommending that, and the failure to appear, the failure to follow through with any violations, that the default be granted and the master certificate and location certificate of Franklin Smoke Time under TC 1480000 and TC 1480001 be revoked. In addition, that the permit under DL 413220 be revoked. I so move.
Second.
Been moved and seconded. Is there any further discussion?
I guess having, this is the most that I recall in my tenure that we have heard of these for both sides. I am astounded at the number of people who fail to appear. You've heard me mention that over and over again. I'm distressed to find that so many of our permittees, and recognize that we have thousands and thousands of them, but that some people just totally disregard their responsibility, even to come in to defend the action or request that the commission consider being lenient with them. I'm astounded at the number of people who just fail to appear upon notification. I just wanted to mention that since we're on the record for people to understand. We expect compliance, but failure to comply, come to us and explain what is going on. Don't ignore the process.
I agree with that. I was gonna note, since this involved nitrous, nitrous is not a commodity that you can sell for purposes of intoxication. Now you can't sell flavored nitrous at our permit locations. It's dangerous. If you're selling it to your community, you need to think about whether you're a value add to your community or whether you're creating harm in your community. So that was my concern. Anything that involves the illegal sale of nitrous is unacceptable. With that, we haven't taken a vote yet. It's been moved and seconded. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next item, consideration of applications. There are 558 renewal applications.
Madam Chair, members of the committee, I incorporate by reference the list of 558 applications for renewal which have been recommended by local boards and reviewed by our staff with authority of the commission. I hereby move approval of the same pending any needed escrow hearings and inclusion of this list as part of the minutes of the October 7, 2025 meeting.
Second.
It's been moved and seconded. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next, item is 55 new and transfer applications.
Madam Chair, I incorporate by reference this list of 55 permit applications for a new permit or applications for changes in ownership or location or both of the existing permits, which have been recommended by local boards and reviewed by a commissioner, and hereby move approval of the same pending a final floor plan approval by the state excise police and an escrow hearing if needed, and inclusion in the list of the minutes of this meeting, October 7th, 2025.
Second.
It's been moved and seconded. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. 83 catering applications.
Madam Chair, members of the committee, I incorporate by reference this list of 83 permit applications for catering and hereby move for approval of same in the inclusion of this list as part of the minutes of the October 7th, 2025 meeting.
Second.
It's been moved and seconded. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. Next item is 6 direct wine shipper applications.
Madam Chair, members of the committee, I finally incorporate by reference the list of 6 new and renewal direct wine shippers permits and hereby move for approval of the same and inclusion of this list as part of the minutes of the October 7th meeting.
Second.
Been moved and seconded. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. I inadvertently, there was a catering application to be added,
Sorry.
and I inadvertently skipped that. It is for, CT 0632848, attached to, RR permit RR 0641756. There was confusion. The RR permit expires in November. So I think there was confusion that it wasn't, that the applicant was intending for it to be part of the 25 to 26 renewal, but they need it for events that are coming up. So it did not get set on the agenda. So this will be an approval, and their attorney is aware from today until early November. And then they'll have to submit a renewal for the next permit year.
Madam
So
Chair, may I
we-
move to amend my motion from 83 catering applications to 84 retrospectively.
Second.
Been moved and seconded. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. All right, next item on the agenda is waivers and fees for letters of extension.
Madam Chair, members of the committee, I move that we accept the waiver of fees for letters of extension that have previously been authorized.
Second.
Been moved and seconded. All those in favor indicate by saying aye. Aye. Opposed, say no. Motion carries. Moving on to items for discussion. The first one is RR 4536364 Playos Nightclub LLC. This is a renewal with the local board voting 3-1 to approve for 1 year and an extension request. This was continued from our last meeting. I'll open that for discussion.
Yes, just want to note that this has been on our agenda for several times. There have been a couple of letters sent by our council asking for information, which has not been completely provided to us. We had requested a corrective action plan, and at our last meeting, we asked for a list or proof of employees and their bartender server permits and training for those, including security staff. On the corrective action plan, we still have not received the dates when those items will be completed. They have a start date. They don't have a date when they're going to have those completed. And on the employee and security proof of their permits and training. On one employee, we received a food handling certificate, which is not alcohol serving, training. So I'm going to, move, I would also note that this permit expired almost a year ago, so we've been dealing with this for quite some time. They're not compliant after several requests. I'm gonna move that we do not allow an extension and we reset this for 2 weeks to review the, renewal, and that will be on October the 21st. And that is my motion.
Second.
Been moved and seconded. Is there any further discussion?
I would like to comment, please. I'm not sure about the corrective action plan. I'm confused on where we are in this. They've failed to do so much, but I have before me a safety plan. And if that's a corrective action plan, I would only point out that I wrote in my notes, too many shoulds. They indicated over and over again that management should, or we should, or what's it called? Promoters should. I would like to see them make specific statements about will and incorporate. And so I would like someone to communicate with them. They need to review the action plan. It's not a wish list. It's not a commitment to think about it. It's a commitment to actually do it, which, and words have meaning. Sometimes I don't like the words that I use because of their meaning, but in this case, they made no commitment to me. So I just comment that as long as we're continuing, it's time for them to either finish this or give up the ship. Okay?
I think we did receive, since they weren't telling us the end date of when their employee training would be, last time we asked them for their employee permit training records and application records. They submitted records indicating that they have 1, 2, 3, 4, 5 people that work either as security checking IDs at the door or servers. I would like excise to visit, well, I guess we're not granting the extension today, so I'll skip that piece, but one of the records for Kendra Skinner, who was required to complete server training by October 13th of 2024, was a food handler training course. The amount of time we've been asking for this and the amount of time the permittee has been saying we should train our employees on alcohol service, and then to get a food handler training course, maybe the applicant has also completed the server training course, and that would be my hope. But the permittee is required to keep those records on hand, and they should have been, you know, filed away at the permit location on October 13th of 24. We had some applications that it looks like some people weren't applying for permits until October 1st of 2025. After we've been back and forth on this for quite a while. I will note they also at local board recommended a renewal 3-1 based on testimony about the permittee's level of compliance, level of commitment, and I think this final 2 weeks here is when they can show us that there is a level of compliance with Title 7.1 and a level of commitment. Now I will note, since the employees that only applied on October 1st just applied, statutorily, they do have 120 days to complete their server training. So, I will note that there was another employee that applied on September 26th. So same thing, 120 days to complete that. Any further discussion? Not seeing any. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next item for discussion is RR 4911398 Tri Entertainment Corporation. This matter previously came on a request to transfer a denied permit. Looking back at our notes, I think sometime in July or August, we granted them the ability to transfer. It's unclear from the minutes whether we specifically granted the renewal for purpose of transfer. So consistent with our prior motion, I would move that we grant a 1-year renewal for the purpose of transfer. Permit shall remain in escrow where it was placed following incidents at the location. I believe the transfer was on the Marion County agenda for yesterday, but I don't have an update on what happened with that. But hopefully that is moving. That's my motion.
Second.
Any further discussion? Not seeing any. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next item is RR 4194243 D&B Keller Enterprises Incorporated, requesting conversion of the permit due to annexation.
Yes, we received the documentation from Bargersville. This has been annexed and allows the permittee to change their license type from a 209 to a 210. We have received all documentation, and I move to allow this conversion of this permit from a 209 to a 210 for RR 4194243 D&B Keller Enterprises, Inc.
Second.
Been moved and seconded. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next item on the agenda, RR 4937692 38th Street Sports Bar and Grill Corp. This permittee is requesting reinstatement. I'll open that for discussion.
This has had a long history with us. The permit has been expired since September the 5th of 22 and was made dead at that sometime after that. It entered into escrow, but it has not kept escrow current. It has been expired in escrow since September 15th of 23. They have now hired an attorney and have taken care of several of the outstanding paperwork issues. We did receive an extension motion to reinstate from their council. And I'm going to move to allow the reinstatement with the following conditions. Number one, before the end of day, next Monday, which is October 13th of 25, file and pay for the 4 outstanding application renewals, including all forms and payment. Number 2, also by the close of business of October 13th of 25, file 3 years of updated escrow request forms so that they can be scheduled for us to consider extending escrow. Noting that the maximum time allowed in escrow may not exceed February the 15th of 27. And we would like those escrow forms to be detailed as to what they're doing to make this business active. 3, I want to note that failure to comply with these 2 previous items before October 13th of 25 will result in the permit reverting to the commission. That is my motion.
I'll second. Is there any further discussion?
I'm going to vote no. And while I appreciate the extra effort being given to this permittee, I am concerned that we may be sending the wrong message to other permittees that they can ignore notices, they can ignore the requirements of renewal, they can ignore requirement to request for escrow, they can fail to pay things that the system that is set up we'll move forward, declare it dead, and then they come back and I don't think it's a good message to send to all of our permittees about what they need to do. Secondly, I think it sets a bad precedent and to totally throw out the work that our fine folks have done over the years on this. They spent a lot of time trying to work with the permittees and the processors and others here. Spend a great deal of time following the rules and regulations, going through the process, and then for us to say, well, but maybe there's some good reasons in this case. There may be some good reasons. But on a case-by-case basis, I think that this sends a message that is unsatisfactory to those who diligently follow the rules and regulations, the thousands of people who follow through with their commitments, follow the paperwork, file the paperwork, pay the money. And while I know we have an interest in making sure that permits are operating and successfully providing the service to the community and so forth, paying their taxes. For those reasons, I'm going to vote no.
I think I keep saying this on all these. I'm torn on this one.
Yeah.
Council did a nice job filing an explanation of recent matters related to the permit.
Yeah.
In looking back at the entire history, it looks like commission staff processed a transfer application on June 22nd of 2021. We didn't receive the orange sign fee until August 9th of 21. Notice was sent of the original tax hold in June of 21, which was cleared on September 9th of 2021. Now, I will note that this was the tax hold on the prior permittee, so not totally within the control of the applicant here. But that was cleared. Local board was set August 2nd of 2021, and no orange sign was posted. September of 2021, there was a continuance requested. October of 2021, the applicant appeared but was missing the Marion County paperwork. November of 21, it was continued for a zoning issue, and the same thing in December of 21. Now, I will note the zoning issue, the notes indicated the zoning issue was confusing because Marion County said they weren't zoned for a bar, even though a bar had been there for 40 years. So that one it was an unexpected hiccup for the applicant. In January of 22, there was no quorum, and then there was finally a vote on granting the transfer in February of 22. At that point, and then the commission approved the transfer on February 16th of 22. And at that point, there still was no tax hold placed on the original permit. But we did not have an escrow form or a final inspection. And while we were waiting for those documents to be completed, that's when the second tax hold was placed that created the issues here. So it seems like at the beginning, we were pulling one document at a time, one piece of information at a time from the permittee or from the applicant, which caused the delay from when we processed the application in June of 21 to when there was finally a vote in February of 22. And but for those delays, that tax hold wouldn't have been placed. So I agree, it sets a bad precedent and it kind of devalues the work our staff does. Sending notice of, we need this piece of information and this one, and you need to get us this one. And on the renewals, my notes indicate that the renewals, the permittee was notified about the renewals in December of 24, but we don't have them yet. I am going to reluctantly vote to reinstate. And I'm not sure if it's been noted, but this was made a pending auction permit and is set on our auction. And we've paid to advertise it for our auction. We're pretty far down the road here. But I am going to reluctantly vote to reinstate. Permittee has counsel now. And based on the motion that we're going to have complete applications, because I think we've been down this road with one piece of information at a time, and they've got to be ready to file a complete application with all supporting documentation to show us that we're really moving through this. I think with the quick turnaround time that we've ordered on that, which really isn't quick because this has all been 4 or 5 years coming. I will reluctantly vote to reinstate with the understanding that if we don't get those much overdue documents, but based on the order today, it will revert to the commission, remain on our auction list, and be auctioned.
So for clarification, I'm sorry, for clarification, are we continuing this or moving forward? So what I heard was by October 13th, these things need to be done, and if not, then are we better off continuing this with this understanding? I'm just suggesting, asking.
Well, the way I had stated it is, that they have to provide us with the application, all supporting forms, payment, and escrow forms by end of day Monday. If those are not here, fully here with everything, all supporting documents, everything here by close of business on Monday, then on Tuesday, that permit reverts to us.
I'm comfortable. Okay.
So, but I guess your question is, if we reinstate today, do we have to vote again to then rescind it back? Where if we leave it pending auction with our order being conditioned on that receipt on Monday, we don't have to flip back and forth if they don't.
I'm comfortable either way.
It's the wording you talked about, and
Correct.
words matter and how we state the order.
We can do either.
Would you amend your motion to
Sure.
leave it pending auction,
Leave it pending auction,
and we'll condition on receiving those?
yes,
Second the amendment.
thank you.
Well, I'll second since you're in the
Okay.
vote.
I'm a no.
Well, you said you are, you haven't voted yet.
I will remain.
All right, with that amended motion, all those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no.
No.
Motion carries. Next, matter for consideration is RR 4641539, Liberty Splits Incorporated. This is a renewal with local board voting 3-0 to deny. I'll open that for discussion.
Yes, this one is also a bit of a complicated issue. This comes to us from LaPorte. I will note that this, 2 owners ago, this business was known as JP Poor Decisions. And it did have, violations and, issues, that resulted in a death from an overservice. And they closed down. New owners, from a full transfer, bought the business. They were operating it.
Marjorie, this was a new application. Not a transfer.
No, that from JD Poor's to the next owner was
It was a new application at that point.
right. That's what I was saying. So the full transfer. Yeah.
No, it was a new application. It was not a transfer.
Okay, I thought it was closed down.
It was closed, but
Changed the name.
it's still denied, and then this was a new application.
Okay,
It only matters for that hearing on certain. That hearing, but Okay, for the record, I just wanted to clarify that.
Okay, thank you for clarifying that. So, it went to a new owner and now they operated for some 6, 8 months. And then they sold the stock to a third owner. So, the new owners, from the stock purchase have had it since July of 2005. And it came up for renewal at the local board. At the local board hearing, it came out that the new owners are using staff from the previous business 2 businesses ago. And that was the staff that was involved in the devastating events from the overservice. It was stated by this new owner at the local board that that staff member isn't working in a bartender service capacity. But when questioned by local board member on this, the new owner stated that that staff person may have slid a drink across the bar sometimes. And that that staff person is behind the bar sometimes. That's very confusing to me. If they're not serving in a bartender server capacity, why would they be touching alcohol, pushing a drink across the bar? Also at that local board hearing, our excise stated that this staff person has been observed serving alcohol. That was in an undercover capacity that observation took place. I just want to note that no one may work as a bartender server without being hired in that capacity, without proof of the server permit and training being monitored and proof kept on file with the business. I also note that no notice of violation was issued to this business, at least not yet. With all that, I'm going to ask excise to continue to monitor this business in an undercover capacity for possible violations. I'm going to have 0 tolerance, at least for me, if there are any violations involving bartender, server, licensing, training, or service from this business. There was a previous corrective action plan submitted from the business, Lickety Splits, from the owners who had the stock previously. I just want to note that all that carries over since this was a stock transfer. All that carries over to the current owners of the business. So if they aren't aware of that, they better become aware of that, because they've committed to things in that corrective action plan on how the business will operate that are still in effect. With all that, I am going to move to overturn the local board and issue this permit for 1 year, asking excise to monitor the business in an undercover capacity for possible violations and noting 0 tolerance involving the bartender server licensing, training, and any alcohol service issues.
Second.
Been moved and seconded. Is there further discussion?
I will be a reluctant yes on this, for all the reasons you've stated. But I also want to comment that, the casual observer of this hearing, or even to an experienced observer, we hear the toughest cases here. And if you just take a look at this proceeding today, we have not only a long docket, but a very complicated, unusual docket. And I just want to note for others that we have literally thousands of permits, and every day we approve 558, for example, renewals. And we've heard now several cases about renewals. It is a process that works. It is easily done if you pay attention to it, follow the rules of business, follow the rules of common sense. Our staff from top to down do a wonderful job at notifying and assisting in this. This is another one of those that, in my opinion, all these events and circumstances don't need to happen. Just follow basic business sense, business logic, and listen and ask the assistance of the processor if necessary. Hire others who are more experienced at this that can help you, whether they're lawyers or others. It's a system that works. Just follow the rules and stay on top of it. But I'm going to vote yes.
We received documents from an attorney hired after the hearing. They were thorough. I appreciated them. I agree that Lickety Splits and its current ownership does not inherit the problems of JD's. I would caution them, however, that I should say the violation problems. I would caution them, well, a couple of things. They do inherit the testimony at the Lickety Splits new application hearing. The owner at that time testified before the local board extensively about distancing the new owner from the problems that JD's had, the issues at JD's. She did indicate at that hearing that she would do extensive background checks on employees, and if violations were found, she may hire them to clear something other than serve alcohol. That sort of matches the testimony that was given about hiring someone back to operate in a capacity that doesn't involve serving, but might involve some serving. So these were the statements that were made to convince the local board that this permittee would not operate in the same capacity as the business that was in the location previously. The local board didn't state their reasons for denial. However, I think if you seek a permit, convince the local board of one thing, and then backpedal in reverse, that may go to character on the applicant. At this point, I'm going to give the benefit of the doubt on that, but I would also caution that there was a switch back in the DBA to JD's. They dropped the 4 decisions, but JD's didn't get to these problems on their own. They had customers coming in who were seeking to drink an excessive amount of alcohol. So I would caution, if you return to JD's, are you leaning back into that culture, that atmosphere, inviting those problems back? And that's a conscious choice that this owner has made to go back to a DBA of JD's. And while you don't inherit the past violations of JD's, if you're trying to be JD's, that may be seen as a problem. If you have issues of your own moving forward. So I would just admonish, you're gonna be watched. You're gonna be watched by local PD, who were clearly tired of the overservice, the DUIs, and the issues, including fatalities coming out of that location. And you're gonna be watched by excise, so we need strict compliance on this. I think the community doesn't want that operation moving forward. So I'm also a reluctant yes to overturn the local board based on no violations and no indication on the votes. But I think there's a high standard for Lickety Splits to prove that they're going to operate in a lawful manner. Any further discussion?
Well said.
All right, not seeing any. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next item for discussion is RR 4538177 CSA Enterprises Incorporated, renewal of local board voting 4-0 to deny.
Yes, I'll note that this permit came before us in June and we did, deny the permit. Then, they had asked for a remand back to the local board, stating that they had had some family health issues that kept the owner from properly running and dealing with issues properly, but things were gonna be taken care of. It went back in front of the local board and they're voting again to deny. I'll note that the permit did expire on May the 20th of 24. It has not had an extension during that time. There was evidence submitted at the local board from social media events where this permittee was operating on an expired permit at least 5 times in 2025. I'm going to move that we uphold the denial of this permit. They were operating when they were expired. Can't do that. There are penalties for that. So for the second time, move to deny the renewal of this permit for RR 4538177 CSA Enterprises Inc.
Second.
Been moved and seconded. Is there any further discussion? I would just note they were continuing to operate while they were expired and not appearing at local board. So they had reasons they couldn't appear at local board, but they were still operating with alcohol. That's concerning. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. Next permit for discussion is RR 4520186, Shades of Time Incorporated. This is a renewal with the local board voting 4-0 to deny.
Yes, this permittee has needed to clear up a tax hold and that has not been completed. So they may not get a permit to operate until they take care of that. I'm gonna make a motion that we uphold the denial for RR 4520186 Shades of Time.
Second.
Been moved and seconded. Any further discussion? Not seeing any. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. Next permit is RR 4542303, David Anguiano. This is a transfer from Shades of Time with the local board. It was unclear to me watching the hearing whether they voted 4-0 to deny or whether they didn't vote because there was no permit to vote on. Either way, the permit has now come to our agenda, so I would open that for discussion.
So since this is related to the previous permit that has been denied, there is no permit to transfer. So I move that this transfer is denied to RR 4542303 David Aguiano.
Second.
Been moved and seconded. Is there any further discussion? Not seeing any. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. Next item is DL 3704928, Red Baron Liquors Incorporated. This matter comes on for an extension request.
This is a package liquor store and runs the Lear. They did expire on July 10th of this year. They had a first extension from July 10th to October the 8th. They had a paperwork issue, which they've now taken care of. They are scheduled for their local board on November the 18th. They need an extension to get through that and back before us to get this renewed. They do not have any violations. I move that we grant a 90-day extension for DL 3704928 Red Baron Liquors Inc.
Second.
It's been moved and seconded. Is there any further discussion? Not seeing any. All those in favor indicate by saying aye. Opposed, say no. Motion carries. The next application is RR 4993208, the Monkey Duck Pub LLC. This matter comes on for an extension request. I will open that matter for discussion.
Yes, this permit expired on October 5th of 25. They did have an extension until today. They have an outstanding violation. I will note that the Marion County Task Force has taken this, permittee up. We have received information that there have been some 72 calls for service over the past 2+ years, related to all kinds of problems, including, a homicide shooting in the parking lot, battery, injuries, disturbance, trespassing. I'll note that almost all of these calls happen after midnight. They always say good things don't happen after midnight, stay home. Yes, this is true for this case. There has been on the violation that's outstanding, our prosecutor has recently sent a settlement offer, has been extended. I will note that they have now hired counsel. They did submit a fairly extensive corrective action plan. I'll note that the permittee and the council both state that they are aware that there's 0 tolerance on this permit. Our prosecutor, I will also note, has placed it on a special program called PACE for enhanced enforcement activity and observation. Make sure that they know what they need to do to operate and that they're complying with all laws and regs of Indiana. Since this violation is more current and the settlement has been extended, I would like to give them some time to look at that and take care of that. I'm going to move that we do grant a 1-month extension only because the violation is outstanding and need time to hopefully work through and get it settled with us. I would like to see some movement on settling that violation within the next month. So the 1-month extension for RR 49-93208, the Mucky Duck Pub LLC.
Second.
It's been moved and seconded. Is there any further discussion?
Just one comment. I've reviewed the corrective action plan several times. I am impressed that they have indicated during weeknights they'll be closing at midnight and on Friday and Saturday closing at 1:30. I think that indicates a real commitment to try to make changes. The other thing I wanted to mention in this that I have not seen before was that the permittee is approaching other bars in the area to try to purchase the same ID scanners that can cross-reference patrons. I think that's a good approach, that we actually share information and not look at these as individuals, but as neighborhood and community systems. So I will support this. I'm concerned about I read the number of police runs there is astounding, but I think they've made progress. I support the motion.
I will just note that I support the motion as well. This is a fairly recent violation that was issued. Permittee and council have been engaged since it was issued. There haven't been unnecessary delays or paperwork issues or failures to appear in this. The violation was issued a number of days before their last extension expired and before their local court hearing was scheduled. So with that, there should be granted time for them to address the violation. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next item for discussion is RR 493361A, Joe Halloran Incorporated. This matter comes on for an extension request.
Yes, this permittee did have a violation, has been paid and taken care of. They did submit a corrective action plan. They have an incomplete, limited separation item with us. And they also need to get us an F1 form completed. We need those two items. As soon as we receive those, then I'm going to move that we grant the extension. So okay for 90 days with the two items noted. As soon as we get those, we'll give you a 90-day extension for R 49-33618 Joe Hall Ran Inc.
Second.
It's been moved and seconded. Is there any further discussion? Not seeing any. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. The next item on the agenda was the extension for R 4536364 Playos Nightclub LLC, which we already handled. Next item is CH 4520984 St. George Serbian Orthodox Church. This matter comes on for an extension request.
Yes, this permittee is up in Cherville. They did expire June the 16th of this year. They had some outstanding items, which they've now gotten to us. They're scheduled for the local board on November the 5th. They did have a first extension from June the 19th to September the 17th. They have no violations. I move that we grant the 90-day extension for CH 4520984 St. George Serbian Orthodox Church.
Second.
It's been moved and seconded. Any further discussion? Not seeing any. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next item for discussion is RC 7105769 St. Joseph Young Men's Society Incorporated of South Bend, Indiana. Maybe. This matter comes on for an extension request. I will open that for discussion.
Yes, I will note that our staff or employee has been working with this business for quite some time. They take care of the name of their organization, their officers, and some other paperwork issues. There has been discussions going on for quite some time. They did expire on January 1st of 25. They had an extension from January 3rd to April the 2nd, from May 28th to August the 28th, for September the 3rd through October the 4th. They have now hired counsel. At the last meeting, we granted some extra time to work with counsel, get the name issue worked out. They are still working on that. We have been getting communication from counsel. I think there's still some question about what the name of this organization is or needs to be, and the appropriate Secretary of State documents and others to back that up. And officers that go along with the business. I'm going to move that we grant one more 30-day extension so they can hopefully with their counsel get this all straightened out in the next 30 days. So 30-day extension for RC 7105769 St. Joseph Young Men's Society Inc. of South Bend, IND.
Reluctant second.
Been moved and seconded. Is there further discussion?
I would like it clear. For some reason, I have this in the back of my mind, and I'm an old guy, intensive information about this. And I know we heard this September 3rd, but I don't recall that. I even checked to see if we had a pending action that would allow me to continue to vote on this. But I practiced law for years. It's been 53 years I've been involved in the legal field, and it seems to me this is a 2-week process to fix. And I've known my name for a long time. I've known my wife's name for a long time. They can't seem to figure out what their name is. And this is a fairly simple thing to solve, but maybe now that they have a lawyer, this can be solved quickly. So I'm reluctantly seconding the voting yes on this, but fix this. But again, we have thousands of permits and they all seem to know who they are. Tell me who you are and decide who you are and fix it. There you go.
Right. I'm hopeful that with an attorney engaged now, they'll be able to do that. With that, all those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next item for discussion is RR 71046660 Studio Roomba 305 Incorporated. This matter comes on for an extension request.
Yes, this is the second, extension request. The first one was May the 22nd of 25 until August the 20th of 25. They had paperwork issue with us. They have now completed all that. They are scheduled for the local board for October 22nd. They need an extension to get through that and have the permit come back in front of us for consideration of the renewal. I'm going to move that we grant a 90-day extension for RR 71046660 Studio Roomba 305 Inc.
Second.
Been moved and seconded. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next item for discussion is RR 4939282 Ice Bar and Lounge LLP. This matter also comes on for an extension request.
Yes, I will note that this was before us in July. We did deny the permit. It is under appeal, and we did deny an extension previously. But new information has recently come to light. And I don't think any of us have had a chance to review it as of yet. I'm going to move that we grant an extension for 2 weeks to look at possible new information that may have impact on this permit. Move for this to be rescheduled on our agenda for 2 weeks for RR 4939282 Ice Bar and Lounge LLP.
Second.
Been moved and seconded. Any further discussion?
Do we have a date that we're gonna?
It's October 21st at 25. It's our next hearing date. Thank you.
All right, all those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next item for consideration is RR 4541247 Tanya's Restaurant LLC. This matter comes on for an extension request.
Yes, this is up in Hobart. This is River Lake permit. It expired June the 19th of 25. They had some outstanding paperwork issues with us that have now been settled. They have a first extension from June the 25th of 25 to September the 23rd of 25. They do not have any violations. They're in front of the local board on November the 5th. I move that we grant a 90-day extension for RR 4541247 Tanya's Restaurant LLC.
Second.
Been moved and seconded. Is there any further discussion? Not seeing any. All those in favor indicate by saying aye. Aye. Opposed, say no. Motion carries. Next item for discussion is RR 4505308 Blanco Incorporated. This matter comes on for an extension request.
Yes, this is another permit from Lake County, a 210 permit. It did expire May the 12th of this year. They did have a first extension from May 29th to August the 27th. They have not had any violations in the past 10 years. They do have a hold. We need a floor plan for an inspection. And as soon as that's completed, then I move that we give them a 90-day extension for RR 4505308 Blanco Inc.
Second.
It's been moved and seconded. Is there any further discussion? Not seeing any. I would just clarify that if their floor plan hasn't changed, they can submit a letter to us stating that it hasn't changed. If it has changed, then they would need a new final inspection and approval. So that could be a quick process, or You have to schedule it out, but those are the two options there. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next item for consideration is RR 4814318 Bear Bond Corporation. This matter comes on for an extension request.
Yes, this, permittee has already had one extension. This is in Madison County. They had some incomplete ownership information, which is now complete. They had a violation. We have received a good corrective action plan from their attorney. And I'm going to move that we grant a 90-day extension for RR 48-14318 Bear Bond Corporation.
Second.
Been moved and seconded. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries, and I apologize, I forgot to open that for further discussion. Okay. Next is RR 4538308 TSA Properties LLC. This matter comes on for an extension request.
Yes, this is another one from Lake County. They have had a first extension. Their renewal is now complete. They do have a pending violation. They haven't appeared for the last two local board. There were no shows. We have requested a corrective action plan from their attorney, which we just received. I think there's additional information that should be added to the corrective action plan. It needs to be cleaned up a little bit. They mentioned things in there like they're gonna close 30 minutes early, but we don't know what time their closing was previously, so we don't know what 30 minutes early means. What time is that? There's other issues like that that we would like to see cleaned up and clarified in the corrective action plan. I'm gonna move that we grant a 2-week extension for this permit, reschedule that time, and hopefully have a corrective action plan that's more detailed and clarifies things like closing the time. And that is for RR 4538308 ESA Properties LLC.
Second.
It's been moved and seconded. Is there further discussion?
I just want to point, I agree on the corrective action plan. As I've read through what I think is the corrective action, there were 3 things that were listed that I thought were good. The others were just statements. I also, number 6 is require staff to communicate any tab swap. I have no idea what that is, but if they're swapping tabs, that may be a good thing.
We can ask them to clarify. It may mean that one employee finishes a shift and switches the tab to somebody else, but we can ask them to clarify.
I've never heard that term before.
Yeah.
And top tabs, I don't know.
There were some on there that it seems like they're trying to address over service, but they say that they will notify management of anyone who's buying large volumes of alcohol for themselves or for the group. But it doesn't say what they do with that information. Do they go ahead and serve it and then tell management? What does management do with it? So it seems like they're trying to get at the right things, but I just want a little more information on, do you serve it? What does management do? Does management step in and deny continued service if the volume is too high? So I agree with granting the 2 weeks and then asking for greater clarification. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next item for discussion is RR 5337838 Yadagarasu Ramen Incorporated. This matter comes on for an extension request.
Yes, they are looking at a second extension. This is from Monroe County. Their first extension expires November the 9th. I will just note that this corporate entity is administratively dissolved with the Secretary of State's office. And there's also a tax protest. They need to give us a clearance on their taxes with the Department of Revenue. I'm going to be a no on the extension. They've got several things they need to take care of. I'm gonna ask legal to send them a letter just stating, need to clear up entity with the Secretary of State's office and clear your tax protests, and then we're gonna reset them for November the 4th to see if they've taken care of items and can get an extension at that time, if they would like one. That's my motion.
Second,
Been moved and seconded. Is there any further discussion?
this is the most I've talked at a meeting since I've been here, but again, administratively dissolved, they don't exist. They can't, if they don't exist, they can't hold a permit. I don't understand why there are so many today that seem this way, and I'm distressed. Again, our staff are wonderful, will help you, but get these things cleared up. That's all.
Well, they have until November 4th. Their
Yeah.
extension doesn't expire until November 9th, so if they can get these matters cleared up, they may not disrupt operations. It's been moved and seconded. All those in favor indicate by saying aye. Aye. Opposed, say no. Motion carries. Next item for discussion is RR 20311180 Miguel Ruiz Ocampo. If this matter comes on for an extension request.
Yes, this is from Elkhart County. They had some paperwork issues, which they've now completed with us, except for the floor plan. We need them to take care of the floor plan, either letter, new floor plan, inspection, whatever is required, take care of that. As soon as the floor plan problem is addressed, then you can get a 90-day extension. That's my motion for RR 20311180 Miguel Ruiz Ocampo.
Second.
Been moved and seconded. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next item for discussion is RR 4927664 El Chispas number 2 LLC. This matter comes on for an extension request.
Yes. This is a third extension request for this permit here in Marion County. They stated they're working on finalizing the lease. They need the landlord's consent, and then they will be filing the transfer. They stated that they will be filing that transfer last week or this week. I'll note that we do have a company that is operating this business under a manager's questionnaire. And seems like they're doing an okay job. I don't know of any problems that have been raised to light under this new management, and I hope not, because they're going to be the ones who are buying it. I hope the transfer is ready to go. I would like to request that by October the 14th, that transfer application be filed. I'm going to move that we grant the extension until that date, and I guess we.
I think their current extension, this may be what's creating the confusion. Their current extension expires October 14th. So they are covered until that date.
But we don't meet next week. So
Could we
give
do
them an extension until the 21st
or condition the grant
on the transfer being
on
filed?
the transfer being filed before the October 14th?
Okay, so, I'll make the motion that we, are requiring the transfer application on or before October the 14th. And once we receive that, we will grant, an extension for RR 492766 Elches Bus number 2 LLC.
Second.
Been moved and seconded. Is there any further discussion? This permit was denied, was granted the opportunity to transfer. I have reluctantly agreed that they can operate on this manager's questionnaire with the arm's length purchaser operating it. But I've been reluctant, so I'd like to see the transfer get through, get the new owner actually on as the owner, and I think that should all be addressed timely here. And it seems like it will be based on the statements they've made, on when that will be filed. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. There are 4 extensions to add to the agenda. One was added to the agenda posted online yesterday. They are RR 3236374 Valentine Enterprises, RR 4998027 El Rodeo number 2 Incorporated, RR 224056 Wimsat Soap Company LLC, and RR 6435393 341 LLC. Can we take it by consent to add those to the agenda?
Consent.
All right, I will show those added to the agenda by consent. And I will call RR 3236374 Valentine Enterprises.
Yes, this is from Hendricks County. They did have a past violation. They've had a first extension from July 20th to October the 19th. The past violation was for serving a minor and minor loitering. That was from a failed SAC check, where they served an individual who was only 18 years old. We do not have a corrective action plan from them. So as soon as we get a corrective action plan, I'm going to recommend that we grant a 90-day extension so they can get through their renewal. I will note that they were scheduled for the Brownsburg local board meeting on September the 2nd and didn't appear for that. So we want to make sure that they appear, deal with the violation, and hopefully move forward with the good operation of this business. So 90-day extension when we get a corrective action plan for RR 3236374 Valentine Enterprises LLC.
Second.
Been moved and seconded. All those in favor indicate, oh, I'm sorry. Oh,
Can I say something?
yeah, thank you.
Again, I know it seems that maybe I didn't get a good night's sleep last night, but I really did. I read this request for extension, and the reason for the extension is listed Miss Local Board. Well, we knew that. That's why you need the extension. Did I offend somebody? Okay. Your Valentine, if you're on, but I'd like some explanation. I don't know that we can deny a request because you didn't tell us why. But why did you miss the Lord? It seemed to me business sense protocol that you would indicate I missed the board meeting because it was in the hospital or because my car broke down or something other than this. It seems to me this is just a violation of the trust that we have that when you make a mistake, you own up to it. You don't just say we did it. And I would like to have seen some explanation and for others listening or share with others, be specific. Life is about communication and relationships. You have a good relationship with our processor. Let them know, let us know when there's a problem. Don't just say, well, we have a problem, but that's your problem to figure it out. So I'm gonna vote yes.
All right, all those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. Next, extension for consideration is RR 4998027 El Rodeo number 2 Incorporated. I'll open that for discussion.
Yes, this is here in Marion County. They're asking for a second extension. They had some items that, needed to be sent to us, and they've now completed that. They are scheduled for the local board on November the 3rd. I move that we grant a 90-day extension for RR 499027, Already of number 2.
Second.
Been moved and seconded. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. Next item for discussion is RR 2240056, Swimsat Soap Company LLC.
Yes, they already have one extension. We were waiting for some paperwork issues. That's now been received. They do not have any violations. I move that we grant a 90-day extension, second 90-day extension for RR 2240056, Swimsat Soap Company LLC.
Second.
Been moved and seconded. Is there any further discussion? Not seeing any. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. Next item for discussion is RR 6435393 LLC. This matter comes on for an extension request.
Yes, we are missing one document from them. That they have one document. As soon as they submit that to us, then I'm gonna move that we grant the 90-day extension. I'll note they do not have any violations. And that is for RR 6435393 LLC.
Second.
Been moved and seconded. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. Unless somebody stops me, I think we're done with our extensions for today.
So I have.
Okay. Inactive files, there are 8 permits to be made inactive that were announced at the 9/16/25 meeting. I will note there that DL 4931524 and DL 4933813 were removed.
Yes, I make a motion to make those 8 permits dead that were previously posted and noticed on September the 16th of 2025. And we are making this dead today.
Second.
Been moved and seconded. All those in favor indicate by saying aye.
Aye.
Opposed, say no. Motion carries. Next permit, 22 permit, or next item, just an announcement, 22 permits to be made inactive. Those are set for the October 21st, 2025 meeting, so get those renewed. If they're yours, this is your courtesy announcement. Just note that there are no escrow hearings in December. Not seeing any other items on the agenda, I would entertain a motion to adjourn.
Move to adjourn.
Second.
It's been moved and seconded. All those in favor indicate by saying aye.
Aye.
Aye. Opposed, say no. Motion carries. We set a record, date.
I think we did this for modern.
Get through that.
Wow.